Mr. Wesley, what's the first case today?
People v. Kelly.
Kelly? I can read it.
Well, let's go the same way.
Let's call to the record docket. What is that?
No, it's a mobile card too. Has an echo to it.
I muted it, so because that's kind of making me crazy. So docket 22-02641, people of the state of Michigan versus Jacob Kelly. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Kelly. He's present and standing to my right.
Sir, you are Jacob Kelly?
Yes.
All right. Mr. Wisty, this is time set for a probable cause conference. It's my understanding that there was an email sent to my staff concerning this case yesterday, but we'll call the case. How are we proceeding today?
Your Honor, it's my understanding defendant would like to waive his right to a preliminary examination at this time, and the people would likewise waive their right.
All right. Let's get the file. And this is an unconditional waiver from both sides?
Correct, Your Honor.
All right. And is that an accurate statement, Mr. Abbott?
It is, Your Honor, and Mr. Kelly was in custody for a while, and I wrote him a letter, and I think before he got the letter, he was out of custody, so my first opportunity to speak with him is this morning. And we do intend to waive the preliminary exam.
All right. May I inquire of your client of the waiver of the preliminary examination?
Yes, thank you.
All right. Mr. Kelly, you understand that this is the time set for a probable cause conference, and both yourself and the prosecutor have a right to a preliminary examination today. All right. A probable cause conference or preliminary examination is a conference in which the people of the state of Michigan would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. Do you understand that?
Yes.
You, of course, could contest any charges. Mr. Abbott is your attorney from the public defender's office. He could cross-examine any witnesses. He could cross-examine any witnesses and contest any charges brought against you today. Do you understand that?
Yes, sir.
Okay. It's my understanding that you intend to waive that right to a preliminary examination today. You'd be done in district court. You'd go to circuit court where this case could continue. My understanding, our negotiations would continue. That's your intent? So your intent today, your wish today is to waive your right to a preliminary examination, leave district court, and go to circuit court for the remainder of the case. All right. I find that the waiver is done freely, understandingly, and voluntarily. This is an unconditional. It's also an unconditional waiver from the people.
Yes, Your Honor.
All right. Prosecutor also waives. So this is bound over to circuit court, where any future date you'll get from Mr. Abbott. All right. That he'll let you know of any circuit court arraignment date or anything along those lines. All right.
Thank you.
Anything else from the people, Mr. Wisty?
No, Your Honor.
Anything, Mr. Abbott?
No, thank you.
All right. Good luck to you, Mr. Kelly. You'll be in circuit court from now on.
Thank you.
All right. Good. Docket 22-02496. People of the State of Michigan versus David Cheney. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. John Abbott for Mr. Cheney. He's present by video today.
Okay, let's go ahead. You might have to unmute them now. I don't think you can you? You still need to talk to your client?
I will in a breakout room, Your Honor.
All right. We muted him because of the feedback. Now we got to get him unmuted. He's unmuted. All right. Sir, you are David Cheney?
Yes, sir.
All right. So we called your case. The attorneys have indicated their presence for the record. Mr. Wisty, how is your proceeding today?
Your Honor, my understanding is there's been a filing for forensic proceedings need to be put on hold.
And is that an accurate statement, Mr. Abbott?
It is, Your Honor. You'll recall you saw that request for a forensic review last week. I believe.
I did.
Yeah.
Okay, so this is adjourned for forensic review that I previously signed. You don't have it? Okay, so we'll need a forensic. I thought I signed a forensic review.
Yeah, you did, Your Honor. You signed an order for a forensic examination
Right.
about a week ago, I believe.
You don't have a package for some reason.
It would have been under a different case.
Oh, it's in a separate file.
They all need to
Yeah, so you'll have to refile for this file also, or else they won't consider it. They'll need the number for this file. Yeah.
Okay.
Yeah. If with 2 or 3 files, they'll treat each file separately, I believe, if I remember correctly.
Okay. I filed one today.
Is that?
I'll file one today.
Okay, all right. Just so long as we meet whatever needs they ask for, but I've got it. So I filed it. I signed the files in a separate file.
Correct.
It's gonna make me crazy. Fine. So I'll indicate for the record what's going on here. We signed a forensic in a separate file. We're going to sign a forensic for this file, and a packet will be sent in this file, just to make sure we're consistent with the forensic center's needs. Anything else for the record on docket 22-02496, Mr. Wiston?
Nothing for the record.
Thank you, Mr. Abbott.
Nothing for the record.
All right, and you'll explain this to your client. All right. We're all set on this file.
Your Honor, may we approach?
You may. I don't think so. So Mr. Cheney is finished in court for his probable cause conference. His attorney, Mr. Abbott's going to reach out to him to speak with him.
What's going on?
Sir, you can talk to your attorney. He's going to come down. He's going to tell you what happened today.
Am I leaving today?
You're free to leave. You're free to leave the Zoom courtroom, sir. Mr. Cheney, you're free to leave the Zoom courtroom.
Okay, all right. Am I leaving today?
No, you're not.
Okay.
I'll call someone. You all set, right?
Yeah.
So we're on the record. Docket 22-02691. That is People of the State of Michigan versus James Lilly. This is the time set for a probable cause conference. I'll have the appearances for the record.
Jake Wisty on behalf of the people.
We are
Yeah.
Attorney Luke
You're
Goodrich
on,
from the
Mr.
Public
Good.
Defender's Office here to represent Mr. Lilly.
And Mr. Lilly is here by phone.
Yes, I have him. I had him give me a call because he has no sound through Zoom.
Okay. But I do see him there with the phone.
Yes, I just turned my phone to speakerphone so he can listen into the court.
All right, perfect. All right, this is the time set, and so you are James Lilly, sir?
Yes, Robert.
Okay, I can hear you. All right, this is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
We'd like it left on for the prelim, Your Honor.
Ten 21. And that's your understanding, Mr. Goodrich, it'll be left on for the preliminary examination on October 21st at 8:30?
Yes, Your Honor.
All right. All right, so we'll see everybody next week on October 21st, on this file 22-02691. Anything else, Mr. Wisty?
No, Your Honor.
Mr. Goodrich?
No, Your Honor. Thank you.
All right, well, Mr. Lilly, we'll see you here next week, okay?
Yes, sir.
Yeah, you're all set.
you're done, just.
Okay.
Sir, on an Ingham County Jail mobile cart, would you please identify yourself?
Jacob Andrew Pembroke.
Okay. Mr. Nichols, that's your client?
That is.
All right.
And I would need a brief breakout room to speak with him about one issue before we're ready to proceed.
All right, I'm gonna have Mr. Nickel and Mr. Farnbrook placed in a breakout room.
One second.
All right, we're on the record in docket 21-02767. It's people of the state of Michigan versus Jacob Farenbrook. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Fahrenbrook.
And sir, you are Jacob Farenbrook?
Yes, Your Honor.
All right, Mr. Wissy, this is the time set for a probable cause conference. How are we proceeding today?
Your Honor, the defendant is in the process of being screened, I believe, for the sobriety court in 55th. I've had some preliminary discussions with Mr. Nickel. I had brought up the possibility of an adjournment, but he had not spoken to his client and indicated he probably would want it left on. And I believe Mr. Nickel also is bringing a bond motion this morning on behalf of his client. So I would defer to the defense attorney for further information.
All right, Mr. Nickel.
Yes, I have had conversations with Mr. Fahrenbrook. He is being screened. His understanding is that interview is set to take place tomorrow with the probation officer that does both the sobriety court program and their substance abuse and alcohol abuse assessments. So that should take place. And we would be requesting that the court consider releasing Mr. Fahrenbrook on a PR bond. He has PR bonds in the other files. He has an updated phone number, stable housing at this point in time, and an understanding that he has got to keep in contact with all of the courts, make all of his court dates, so that he can get these cases resolved. He has a desire to get them resolved and get into outpatient drug treatment so that he can get his substance abuse issues under control. So we would request that the court modify his bond to a PR bond at this time.
So the first one is this is adjourned to prelim, the prelim's adjourned, is that correct?
I believe we're leaving the prelim on.
Okay, so it's left on for prelim. So it's left on for prelim on October 21st, 2022 at 9 a.m. So that's your understanding, Mr. Nickel, it's being left on for prelim at this point?
Yes.
Okay, I know there's other things going on. So Mr. Fahrenbrook, you understand that it's being left on for prelim at this point. Your next court date is October 21st, 2022 at 9 a.m.
Crystal clear, Your Honor.
All right. And then Mr. Wisty, in regards to the motion for bond.
Yes, the people would oppose any bond modification. Well, he is being considered for a sobriety court. He still remains in consideration. It's no guarantee that he would get in, although I would wish him the best. And we have missed court dates here and we have missed court dates in the other files. He was on a bench warrant status from what I'm looking at for a long period of time. I would be concerned that he does not return to court if he is granted a PR bond. And for that reason, I would request they stay in place.
Right. I have the bond is set by Judge Simmons at 5,000 cash surety. I have one failed to appear in October 18th. I have a second failed to appear in February of 2022. So there may be a bond reduction here, but it's going to be sometime after he's looked at and screened, because he simply doesn't have a record of showing for court, and he simply wouldn't have a record for showing up to be screened at this point in time. So I'm gonna deny the motion to reduce bond at this point. They know where he is, they can screen him, and then we can go from there. So the bond reduction is denied.
That's not right. I was diagnosed with COVID-19. That's not right. I didn't miss my court date. I did my pretrial services as asked.
Anything else, Mr. Wisty, on docket 21-02767?
No, Your Honor.
Anything, Mr. Nickel?
Nothing further at this time, Your Honor.
All right, thank you. That's all for the record in this file.
How can you guys do that to me, man? This is ridiculous. It's just a joke, right?
Mr. Nicola, you might want to inform your client and the courtroom can hear him so that
Yeah, Mr.
you might
Fehrenbach,
wanna-
you're good to leave the room.
Yes, sir.
All right.
Yes, sir.
Thank you, Mr. Nicola.
Yes, Your Honor. Thank you.
Sir, on the Ingham Jail mobile cart, will you please identify yourself?
Todd Blemmo.
All right, and Mr. Goodrich, Mr. Blamo is your client?
Yes, can I speak with him,
Did you need
please?
some? Sure, I'm gonna have you rejoin room 1 and we'll place Mr. Blamo in that room with you.
All right, thank you.
Okay, on the record in docket 22-02652, people of the state of Michigan versus Tribe Blamo. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Blamo.
And sir, you are Tribe Blamo?
Yes, sir.
All right. This is the time set for probable cause conference. Mr. Wisty, how are we proceeding?
It's my understanding that the defendant would like to waive his 21 days to hire private counsel.
Is that your understanding, Mr. Goodrich?
Yes, Your Honor. And speaking with Mr. Blamo, him and his family have been in contact with Fred Blackman and they're anticipating hiring him. So rather than have Mr. Blackman come in next Friday and ask for an adjournment, we would like to waive the 21 days today and get a new date.
All right. So, Mr. Goodrich, may I inquire your client, Mr. Blamo, concerning his 21-day waiver?
Yes, Your Honor.
Mr. Blamer, you understand you have the right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, sir.
Yeah, it's my understanding that you're willing to waive that right to have that prelim within 21 days in order to adjourn this matter to hire a private attorney, Fred Blackman. Is that fine? Is that correct?
Yes, sir.
All right. The preliminary examination within 21 days is your right in regards to having a probable cause hearing in which the prosecutor must prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, would be represented by counsel in that proceeding to cross-examine any witnesses or to contest any charges brought against you. You have that right to have it within 21 days. If you waive today, you're not waiving your right to a preliminary examination. You're just waiving your right to a preliminary examination within 21 days. Do you understand that, sir?
Yes, sir.
Is it your intention today to waive your right to a preliminary examination within 21 days of your date of arraignment?
Yes, sir.
Okay, I find the waiver of the 21-day rule to be freely understandingly and voluntarily made. And we will reset the preliminary examination for
October 28th at 8:30.
October 28th at 8:30. At which time Mr. Wisty and the anticipated Mr. Blackman will have the opportunity to discuss the case. All right, sir? So you're set for October 28th at 8:30. All right, Mr. Blamo?
Yes, sir. Thank you.
All right. Anything else for the record in docket 22-02652, Mr. Wisty?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor. Thank you.
All right, you're all set, Mr. Blamo. We'll see you on the 28th, all right?
Thank you.
Okay. Mr. Watkins, your attorney will be here in just a second. He's in another courtroom, okay? Because I think that's good. No worries. All right, we're on the record in docket 22-02653. That's people of the state of Michigan versus Kedrick Anthony Watkins Jr. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Your Honor, good afternoon, good morning, Assistant Public Defender Stephen Feigelson on behalf of Mr. Watkins.
And sir, just for the record, you are Kedrick Anthony Watkins Jr.
Yes, sir.
Okay, and I want to just confirm that's Kedrick, Kedrick.
Yes, sir.
All right, thank you. That was the source. I think we had it twice, but so on the record, it's Kedrick, not the other spelling that was part of the record or part of the warrant. Mr. Wisty, this is the time set for a probable cause conference. How are we proceeding?
Your Honor, my understanding is this will be left on for preliminary examination.
And Mr. Feigelson, that's your understanding?
It is, Your Honor. At this time, there are no offers, and I will meet with Mr. Watkins either tomorrow or Monday to go over his options for the next step, Your Honor.
All right. Mr. Watkins, you understand that this is a probable cause conference, and at this time, we're going to leave the prelim on for next week, October 21st, 2022 at 9 a.m.
Yes, sir.
All right. Mr. Feigelson, your lawyer will relay any information from the prosecutor's office. Anything else for the record in docket 22-02653, Mr. Wisty?
No, Your Honor.
Anything, Mr. Feigelson?
No, Your Honor. Thank you.
All right, you're all set, Mr. Watkins. We'll see you next week.
I got a question. So I haven't like talked to none of my lawyers or nothing since I've been in here. So like I'm not getting why I'm still in here and I'm bonded out. And
But why don't you talk to your lawyer tomorrow? Because I think he's going to polycom tomorrow, and you can have these conversations with him concerning any bond reduction.
Judge, what's the bond presently set at now?
Bond is presently set at
5,000 cash.
5,000 cash.
You know, did you know if he, because he may be saying he's already posted on this. Is that correct, Mr. Watkins?
yes, that's exactly what I'm saying. And I'm getting on the phone and hearing this saying I don't got no charges or anything going on. So I'm confused to why I'm even locked up and I just bonded out. I'm not guilty. I'm not supposed to be in here right now. I'm supposed to be innocent until proven guilty. Y'all act like I don't know my rights. It's not making sense to me. It really,
Judge, because I don't.
it's illegal, bro. This is illegal.
Given some of the information with his name to the jail.
Right.
Makes him
I can only tell you what I know right now, and that is that the computer indicates that he has not posted bond, but you should follow up in regards to Kendrick or Kedrick.
I'll check with the clerk staff.
Yeah.
Excuse me, sir. It says that I don't have any bond in here, and it says I don't have any charges in here. It's not making sense.
Right, you do have it's a 5,000 cash surety bond. So, but I would follow whether it's under N or D.
I found the bond. I think he held up something else, but we'll have the clerk's call.
All right. So we did find the bond. We're gonna have the clerks verify what his bond is under the right name. It appears he might be being held on something else, but we're not sure. Okay,
I'm gonna dig into this and I'll let you know something tomorrow, Mr. Watkins.
all right, and then you can contact Ms. Holden because she'll look into it too.
And
Okay,
pull your arm.
all right,
Okay, thank you.
all right. You're all set, Mr. Watkins. All right, we're on the record in docket 22-02508. That's people of the state of Michigan versus Angela Abbott Stewart. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Abbott Stewart. And Your Honor, I would need to briefly speak with her before continuing.
All right, let's place, I'll have yourself and Ms. Abbott Stewart placed in a breakout room. And Mr. Goodrich, you can rejoin room 1. I like that when it's so fast. All right, and ma'am, you are Angela Abbott Stewart.
Yes, John.
All right, and you've had the opportunity to speak with Attorney Luke Goodrich in a breakout room.
Yes, John.
All right, this is a probable cause conference. Mr. Whiskey, how are we proceeding today?
Your Honor, myself and defense counsel have had discussions regarding a resolution to this matter that involves sobriety court in 55th. It may be prudent to adjourn this matter in order for some screenings to get done. And I would defer to Mr. Goodrich how he'd like to proceed after he's communicated those things to his client.
Mr. Goodrich?
That is accurate, Your Honor. Ms. Abbott Stewart would like to waive for 21 days and have this matter adjourned probably out another 2 weeks to give time for screening in 55th. I think we're going to have some resolution based on what goes on in that 55th case.
All right, Mr. Goodrich, may I inquire of your client of the 21-day rule?
Yes, Your Honor.
Miss Abbott Stewart, you realize that today is set for probable cause conference. By law, you have the right to have an arraignment within 21. I'm sorry, you have the right to have a preliminary examination within 21 days of date of arraignment, which would be next week. It's my understanding that you wish to waive your right to a prelim within 21 days in order to seek screening for the 55th District Specialty Court. If of course that would be only waiving your right to a prelim within 21 days, not waiving your right to a prelim. Is that your intent today, ma'am?
Yes, Your Honor.
All right. And you understand that a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and probable cause evidence of the identity of the person who committed that crime in this file. If you waive your right to have that probable cause hearing, the preliminary examination within 21 days, you will not be waiving your right to a prelim. You'll only be waiving your right to a prelim within that time period. Do you understand that, ma'am?
Yes, Your Honor.
Is your wish today to waive your right to a preliminary examination within 21 days?
Yes, Your Honor.
All right. I find the waiver of the 21-day rule to be understanding, voluntarily, and accurate, and we'll set this for prelim
October 28th.
on October 28th at 8:30. Ma'am, please keep in contact with your attorney, Mr. Goodrich, in regards to the screening and those factors. Mr. Wisty, anything else for the record in file 22-02-508?
No, Your Honor.
Anything else, Mr. Goodrich?
No, Your Honor. Thank you.
All right, Miss Abbott Stewart, you're all set today, okay?
Yes, Your Honor. Thank you.
Thank you.
Okay, thank you, Your Honor.
All right, thank you, Mr. Goodrich. All right, we're on the record in docket 22-0151, People of the State of Michigan versus Anjanette Shares Horton. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Jacob Starr, Support, Assistant Public Defender, here on behalf of Ms. Horton. She's present. She's at council table. She's seated to my right.
All right, and ma'am, you are Anjanette S. Horton?
Yes.
All right. This is the time set for preliminary examination. How are we proceeding, Mr. Wisty?
We're proceeding with the examination.
All right. Are there any preliminary matters to come to the court's attention?
Yes, Your Honor, we would agree to a sequestration of witnesses. However, I would like my lead investigator, Detective Wynacott, to be able to be permitted to sit next to me for the proceedings as the lead investigator.
Mr. Sartz, any objection to the detective being present? I don't see any witnesses in the courtroom, so.
Well, Your Honor, I believe the detective would be allowed, even with the sequestration order, to be present at council table. So for that reason, pursuant to the applicable court rule, I won't be objecting to that. But I would reiterate the request for sequestration order because there are a lot of potential witnesses here. Thank you.
All right. So I'll leave it to council to bring it to my attention if any witnesses come in during the proceedings so that we'll make sure they're out. And I'll indicate if somebody has come in. I don't know the witnesses, but we'll just make sure to be vigilant. And then the detective, of course, pursuant to statute, can stay. Mr. Wisty, you may call your first witness.
Your Honor, before I call a witness, the people would move to submit What's been marked as plaintiff's exhibit 1 is a copy of the Lansing Fire Department Fire Marshal's arson report on this matter. And we move to admit it pursuant to MCL 766.11B, which provides such evidence to be admitted at a preliminary examination without regards to the rules against hearsay and without requiring testimony of the author, report keeper of records, or any additional foundation or authentication.
Mr. Starks, a response to the motion for People's Exhibit 1.
That's what we'll be objecting to that, Your Honor.
All right. Just an open objection to the exhibit.
Based on lack of foundation, based on the lack of the notice that the prosecutor was not intending to call a foundational witness as relates, and based on, for the reasons also, Your Honor, on the importance of potentially having a fire investigator in a case like this, potentially being available to testify for the purposes of discovery. So for those reasons, Your Honor, the defense would object. Thank you.
All right, response, Mr. Wisting.
Your Honor, the statute provides for this sort of evidence to be entered at the preliminary examination.
I will allow the exhibits. The plaintiff's Exhibit 1 is admitted.
May I approach, Your Honor?
You may. Thank you. And Mr. Wisting, you may call your first witness.
People would call Terrence Wright.
All right, Mr. Wright, I'm going to have you stand right in front of me. I'm going to please, just for my court reporter, indicate your name and spell your last name for the record.
Terrence Roy Wright, W-R-I-T-H-T.
Okay, sir, would you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, you can sit here and have you project as loud as you can
Yep.
for recording purposes.
Permission to proceed, Your
You
Honor.
may proceed.
Morning, sir. Once again, could you state your name for the record?
Terrence Roy Wright.
And do you know a woman by the name of Anjanette Cherise Horton?
Yes,
And how do you know her?
my ex-girlfriend.
Do you see her here today in the courtroom?
Yes.
Could you point to her and identify something she's wearing?
Gray, black and gray sweater.
May the record reflect the witness has identified the defendant?
Any objection?
Yes, Your Honor, lack of foundation. Thank you.
Okay. With that understanding, the witness has identified the defendant.
Mr. Wright, something happened involving you and Miss Horton on June 16th, 2021.
Yes.
And what was that? Or may I withdraw the question, Your Honor?
You may.
On June 19th, 2021. It's not, let me, just for the record, full question.
Altercation.
What day did that happen?
The 19th.
What month and what year?
June.
And what was that altercation?
I knocked on my door. It was Angie, open the door. We got the, she barged her way in, also, whatever.
And she barged her way in. Could you elaborate on that?
All right, I'm just going to have you speak as loudly as you can.
Yeah, she barged her way in. She basically tried to barge her way in. We got to tussling. I'm like, nah, go ahead, go.
Where is, she barged her
My
way
apartment.
into where? Where is your
My
apartment
apartment.
located?
Bayview.
What's the address? You said it's on Bayview what?
Bayview Drive,
What city is that in?
Lansing,
Is there a name of the apartment complex or anything?
it's Bayview,
The name is the Bayview Apartments. Lansing, that's in Ingham County.
yes.
Okay. So you were at your apartment, was this, what time of day was this?
One-ish. About 1 o'clock.
So you were there alone and from
Yes.
there, you had testified that she barged in.
Yes, correct.
Could you elaborate on what you mean when you say she barged in?
Tried to knock on my door and You know, I opened the door, didn't know who it was. I got up, opened the door, didn't know who it was. You know, once I opened the door, she and I, you know, I'm like, you know, because we used to going through the same rigmarole, you know. I'm like, oh, you know what I'm saying? No.
Objection. Hearsay, Your Honor. His statements are hearsay.
Response?
Say that could be that's an excited utterance, I would say, if the record, I can ask another question.
I'm gonna allow it under, it's not offered for the truth. At this point, I don't see any of this offered for the truth. Just being offered to show what essentially happened next, so I'll overrule the objection.
Thank you, Your Honor.
Did she have any permission to be in that apartment that
No.
night? When she's outside, how did she get into the apartment?
Actually, I opened the door, but as I said, she barged in. We got, you know, got the tussle. I'm saying, go get out.
Did you open the door to let her in?
Yeah.
Okay, did you let her into the apartment? Did you have permission to come through?
No, not the downstairs, but you know, once I basically didn't know who it was. I opened the door, you know. She and I, we got, you know, tussling, and I'm like, go on, get up out of here. You know, then once I seen how heated it got, you know, I grabbed my phone and I went downstairs, called the police. And that was me about like one-ish, whatever. And by the time I got downstairs, I seen my Buddha.
Objection. We're starting to get kind of into the narrative here.
Okay, so let the prosecutor answer the questions, but right now I've got you right at as you're going down, you went downstairs to make a phone call to 911. Okay.
Yeah, I called the police.
After you got to respond to the question, so
Okay.
I might cut you off to ask a question. That's okay. So you're downstairs to call the police. What happens next?
I see my Buddha statue, my fan, and the plant and weights and other things go flying off my balcony.
And just so visual, you're on the second floor. What floor is your?
I live on the
apartment?
second floor.
Okay, so you've gone down to the first floor and you
Yes,
see
sir.
these things coming off.
Yes.
Any idea why they were coming off?
Because Angie, she was irate and didn't want to leave and wasn't.
Objection. Speculation. Gonna observe it from the way he's describing based on.
See anybody?
So we'll rephrase. And how did you know it was Angie?
She and I was only one in the apartment.
Okay, you may proceed.
After you saw these things coming off the balcony, what did you do next?
Ran back upstairs, you know, and basically engaged the situation. She was irate. I seen it. She brandished a knife, and I'm like, okay, I can't win this situation.
Where were you when she brandished the knife?
Approximately, I say about where the desk is at.
Did you
Get
feel?
in the desk.
So let the record reflect 6 to 8 feet.
Correct.
Did you feel as though she could have reached you with that knife at that time?
Yes.
And did you feel that you were under stabbed with that knife?
Yes.
At that time? Point, did you ever tell her to leave the apartment?
Excuse me?
Did you ever tell her to leave?
Objection, because it's gonna call for hearsay in the response.
Yeah,
I would
What he
guess it
said.
Goes to a legal, it's a legal fact whether or not she had permission to be in the apartment, whether he gave her notice. So go to the
She's
second.
supposed to be on the property period.
all right. So I guess you can ask him in respect to, from his understanding, whether she's allowed to be on the property.
From your understanding, was she allowed to be in that apartment?
No.
when this was going on? So we're at the incident with the knife. What happened after that?
I immediately ran back downstairs and retreated over to Dollar General to call my family members. That's when I got a phone call.
What happened when you got that phone call?
That my apartment was on fire.
About how much time?
Objection, that calls for hearsay in the response as well.
Hearsay.
I guess that would be for the effect on the list, but what I'm looking for is when he became aware of the allegations that his house was on fire, not that the allegations themselves are accurate.
I'll allow it, overruled. Did you do something in response to what was told to you about your house being on fire?
Just retreated and fell back in disbelief.
Okay.
Yes. Watch in disbelief.
You were able to see your house on fire?
Yeah, because it's a trail right there.
About how much time had passed from when you left the apartment?
I per se, I don't, per se, I can't say exactly.
Were you able to make an estimate?
Half an hour, 20 minutes.
So if I heard that correctly, it was about 20 minutes between the time you left and the time you saw the fire?
Yeah, because I was on the phone over at Dollar General and peeking through the alleyway, you know. Once I got the phone calls, I doubled back and looking at the, you know.
All right.
Do you recall making any statements to police regarding this incident?
No.
You don't recall making any statements?
Oh, yeah, yeah.
When did you make statements?
It was a day or two after the incident itself.
And do you believe looking at a report of those statements may refresh your recollection?
Correct.
I'm gonna object, Your Honor, on lack of foundation here. Is this being brought in for impeachment, or what's the purpose of attempting to refresh the memory of the witness when the witness has testified that they couldn't remember?
I agree. So the objection sustained. And then you can lay foundation as to whether he remembered what statements was made.
Oh, okay.
Do you recall making statements to the police officers at that?
Yes.
Well, objection, same issue.
Do you recall making a statement that it was 10 to 15 minutes from the time you left your apartment to the time you received it?
Right.
Okay, so you do recall that
Yes.
statement? And that was made, when was that made in relation to when the incident happened?
30-ish, 40-ish.
When did you talk to the police after the house?
That was a couple of days because I was in fear of me going to jail because of the warrants I had. So I, me being me, I didn't talk to nobody and just wanted and just soak it all up. I lost everything I had in my home.
So earlier when you were in your apartment, was there anybody else there besides you and the defendant?
No.
No further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. Mr. Wright, are you a smoker? Are you a smoker?
Yes.
Were you a smoker back in around June 19th of 2021?
Yes.
Okay. Did you have cigarettes in the location?
No.
You didn't have any cigarettes in your apartment?
I was broke. I was over at my friend's house. No.
Okay, so you never kept cigarettes in your apartment?
I mean, if I had them, no, I didn't have no cigarettes.
Okay,
I was
but
broke.
did you have combustible materials in your apartment such as candles, lighters, matches, anything like that?
Only lighter I had, it was a big that was in my carry-on.
Okay. Did you have any candles in the apartment?
Yes.
And had you used the candles in that apartment previously?
No.
You had candles in your apartment, but you never used them.
You said previously. No.
You had never.
Not that night. No.
Okay, but you had them in your apartment, correct?
Right.
And did you have matches in your apartment?
No.
You didn't have any matches in your
I
apartment?
had no matches.
Okay. So back on June 19th, 2021, you said something about warrants.
Yes.
Correct? That's what you testified to earlier?
Yes, correct.
What did you have warrants for?
Parking tickets. Matter of fact, it's a parking ticket and plate, I want to say, or no insurance.
Okay.
Yes.
And had you been drinking that day?
Yes, sir.
Okay. And prior to 1 o'clock, isn't it true that you'd actually called Mrs. Horton previously?
No.
No? So you deny that you made any phone call to Ms. Horton? You deny that you asked her over?
Can't recall.
Can't recall.
No, sir.
Okay. So, but you'd been over that apartment previously, correct?
She's my ex. I mean, she was my girlfriend at that point in time.
She was your girlfriend at that point in time, is what you're saying.
You know, off and on, yes.
Okay. So she'd been up there before with your permission, correct?
Correct.
All right. So how drunk were you that day?
I was alleviated. Don't know.
You don't know. Okay. So your testimony after your initial encounter with Miss Horton is that you retreated downstairs, correct?
Correct.
Okay. And you recall approximately what time that was?
1-ish.
1-ish. Okay. And then you went back upstairs?
Yep.
All right. Did you attempt to take the knife from Miss Horton?
Despite the flight, I seen the knife. I attempted, but I fled.
Okay.
Went back down my stairs.
Now, the first time that Miss Horton came in, do you recall approximately what time that was?
No.
And did you put your hands on her at that point?
No.
So you didn't, that argument did not turn physical,
No.
but it was very verbal though, correct? Loud?
Can't recall.
You can't recall because you're drunk, right?
Objection, argumentative.
Yeah.
So I'll sustain the objection. If he doesn't recall because he'd been drinking, you can ask that question.
Thank you. Do you not recall because you're drinking?
Already answered.
Okay. And what about marijuana? Were you smoking marijuana that day?
Can't recall.
Can't recall. Okay, how about other drugs? Were you using anything else at that time?
Can't recall.
How about antipsychotics? Any prescription medication that might have influenced your memory?
No.
What about crack? Had you been smoking crack at that day?
Can't recall.
Can't recall. Okay. And you said after you attempted to retrieve the knife, how did you attempt to do that? Sure. You described that you had a knife brandished, but you just testified that you did attempt to
I
try to
ran
get
back
it.
upstairs. She was approximately from here to here. She bent it. She pulled the knife. I went back down. I mean, I'm like, yeah, I advanced, but I can't win. She was already standing before, so I can't win.
Okay. So you did not attempt then to get the knife from her?
No,
Okay.
I fled.
You fled. So after you left your apartment, where did you go?
It's already stated. Dollar General.
Okay. Down to Dollar General. How far is the Dollar General from that location?
If a half a block.
Okay, half a block. But you never turned back. You never looked at your apartment when you're going down to Dollar General, right?
I told you I was looking back at the same time as I was getting phone calls.
Okay. You're looking back, but the house wasn't, you didn't see any fire at that point.
Not at that point.
And you didn't see any other falling objects or anything else at that point, correct?
Excuse me.
Sure. You testified. So
Falling
where,
objects.
yeah, you mentioned that you saw some of your
I'm
items.
gone now. I'm away from my apartment. So how can I see some fallen objects? I'm away from it.
Okay, so you had no view of your apartment when you're going to Dollar General.
No.
So you couldn't see who was entering or leaving your apartment, and you couldn't see who was entering or leaving the building either, correct?
Nobody but Angie was there.
Okay. So there weren't other occupants in the building at the time?
Not in my apartment.
Okay, well, describe the apartment building. What's the layout of the apartment building?
It's four apartments.
Okay, and you said there's a downstairs and an upstairs, correct?
2 down, 2 up.
Okay, so there's 4 units in total.
Correct.
Okay, so 4 different apartments in a particular building.
Correct.
2 upstairs, 2 downstairs. Correct? So when you retreated downstairs.
Is that a yes or I didn't?
Yes.
Okay, so
Yes.
after Ms. Horton first came in, which you admit you opened up the door, correct?
Right.
Okay, so you opened up the door, you let whoever was coming in, let him come in, correct?
Angie? Yes.
Okay. And is there an outside security guard that a person needs to go through first in order to get into the main building?
Yes.
Okay, so how does that work? Can a person get in then without some type of buzzer system or something along those lines, or is that downstairs door open?
Downstairs there was open.
Okay. So the downstairs door was open. Where specifically did you retreat then after the initial encounter with Angie? Where did you go in the
I
building?
already answered.
Where?
Downstairs.
Downstairs into what? Into a hallway, into another apartment?
No, my front, right, open the door and I see my belongings being thrown off my patio.
Okay, so were you outside the building? Where specifically were you located on the grounds?
The steps, it's the steps to as soon as you open the door.
Okay, so there's steps. And so from the steps, you claim you observed possessions that were falling off your balcony,
My
correct?
Buddha, my fan, yes.
Okay. And approximately how far were these steps from your apartment?
They adjoined the apartment, man.
Okay. And so you observed your stuff falling off the balcony and then you went back upstairs. Okay. And you saw the knife, but that's when you claim you retreated, correct? You didn't try to recover the knife at all? You didn't put your hands on her? Okay. And then you retreated, but you went all the way to Dollar General, correct?
Yes,
So you couldn't see anybody who was going in and out of the building, correct?
correct,
Correct. All right. And you didn't see any fire at that point, correct?
correct.
All right. So you didn't hear about the fire until approximately what time?
I don't know.
You don't know.
Until I got the phone calls of people telling me, you know, your shit is on fire.
Okay,
That's when I doubled back, went and looked, you know.
but you don't know what time that was. Okay. Nothing further, Your Honor. Thank you.
Redirect?
Yes, Your Honor. When you left, you said you just testified you did not see anybody going in and out of the building when you left. Did anybody besides Angie arrive at the department before you left? Did Angie arrive with anybody that you come home?
No.
And there was nobody else in the apartment when you left
No.
except Angie? And just for clarification, I believe you testified both that you had let Angie in that evening and that she did not have permission to be in there. Which statement is accurate?
That's correct. She didn't have permission to be on the property. However, I opened the door, she barged in, and then that's when the confrontation ensued.
So when you opened the door, did you need to let her in?
No, because I didn't know who it was in my people. I didn't actually see her, so
So you opened the door because you don't know who it is,
correct.
and then Angie, you recognize Angie then at that point.
Correct.
And then what does she do?
We got this arguing, tussling, we didn't find it. She told me I
Before
was
she
leaving.
gets into your apartment, how does she get into it? Does she go through you to get to your apartment?
Did she go?
Through me, through you, yes. Does she push you out of the way to get in?
Pretty much, yeah.
Does she push the door out of the way?
Pretty much, yeah. Yeah.
And at that point, she wasn't given permission to be here.
No.
When you left the apartment, you didn't leave any cigarette smoking?
No,
Did you leave any candles lit?
no, sir.
Was there anything on that could have caused
No,
potential
sir.
of the fire? You had been at least drinking that evening, but
Yes.
is anything you testified to not something you actually remember today?
No, sir.
No further questions, Your Honor.
May this witness be excused.
I,
Mr. Sartz, any further questions?
No further
All right.
questions.
Without objection, the witness is excused. Mr. Wisty, any further witnesses?
yes, Your Honor, I would call Detective Wanacott.
So you, Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, they do.
Okay, let me have you spell your last name.
Planning witness is still in here. We still have a sequestration.
All
order
right, so
on it.
we have a sequestration order, so you'll have to leave so that you don't see anybody else's testimony, sir. Okay.
Thank you, Your Honor.
Spell your last name for the record.
It's Wanacott, Wonnacott.
All right, thank you, sir. You can have a seat.
Permission to proceed, Your Honor?
You may.
Thank you, Your Honor. Again, could you state your name for the record?
Detective Jeremiah Wanacott, Jeremiah, Wanacott, Wonnacott.
And you're a detective, obviously. Where are you employed?
City of Lansing, Lansing Police Department.
How long have you been there?
Since I was 18, I started in 1996 as a cadet and then became a police officer in 1999. And a detective since 2014.
What do you do in that role?
Well, I wear two hats. I do domestic violence. I investigate domestic violence cases. I'm also the department's arson and fire investigator.
Were you involved in an investigation on June 19th, 2021?
Yes, it was.
Where was that? What location of the investigation took place?
River Shell Apartments located at 3605 Bayview. The focus of the fire was apartment 112.
Is that city of Lansing,
This is in the city of Lansing.
county of Hingham?
It's actually Eaton County, but I'm not positive.
When you arrived, when you first arrived at the scene, what did you do?
I arrived around 6:06 in the morning. I had been briefed several times by the acting fire marshal, Mark Berger, throughout the evening. I think the first call was around 3:00 in the morning. I was told that there was a domestic type disturbance and a fire, and he was asking for my assistance. I told him until the fire could be put out, there's really not anything I could do at that point. There did become a time around 6:00 where I was called by Mark Berger again, requesting assistance. I contacted my supervisor and he gave me permission to come in. At that point, I assisted with the investigation.
Physically on the scene, correct?
I was physically on the scene at 6:06.
Can you describe the building?
The building is a brick two-story building. It has 3 units. Each unit, I believe, has 4 apartments and it's all connected.
And when you got on the scene that morning, then what happened from there?
So the first thing, I'm a certified fire investigator. I have the same credentials as the fire department, fire marshals, fire investigators.
But in this particular, you didn't prepare the report.
That is correct. My job is criminality, not origin and cause. The 2 paths to get there are similar, but ultimately different. So what I did was I got a briefing from the OIC there, which was Mark Berger. Mark Berger, the acting fire chief at the time for Lansing Fire Marshal's Office, told me that there's some type of domestic disturbance that was reported and that the fire had been put out. A fireman had stepped through a hole. They went out safe to go in. They examined the area of the apartment. There was a couple areas that had irregular burn holes.
Your Honor, we're kind of getting into a narrative here at this point, so I would just object that it's beyond the scope of the initial question.
I'll sustain the objection and you can break it up with some questions.
So you got there, you did the initial assessment. Are you physically inside the apartment then looking around?
No, I don't do that until we obtain a warrant.
Okay. I guess before we cut off, where were you at today?
We learned that there looked to be the fire was suspicious in nature.
What were the reasons for that?
Yes, there are irregular burn patterns, according to the acting fire chief at the time. And due to the nature of what happened before, the 911 callers just said they could see it as a type of.
I'm going to object to lack of foundation here, Your Honor.
I'll sustain the objection. I think this testimony we've had concerning the initial call, so.
Okay. So let's skip ahead, post the initial call. What were the other reasons? Okay, so let's back. So I had asked you what were the reasons why you thought it was suspicious related to domestic. There were some physical things about the building you spoke about. Anything besides the things you've spoken about already?
I know through training experience that oftentimes domestics can lead to volatile situations.
Was there anything besides?
The irregular burn patterns that were located inside.
Could you elaborate on what are those? What do you think?
Okay, sometimes it can be an indication of arson, in particular that
Your Honor, I'm going to object on lack of foundation here. This person has not been introduced as an expert, and he's just supposed to testify based on his recollections of what he did, sir. Thank you.
Response?
At this point, I don't intend to certify the detective as an expert, although I believe I could. So I would just ask that that portions be stricken and just testify to it.
I think he has the training of experience to testify to these matters. If I think he's going out of that the expert witness into the expert witness testimony, I'll sustain any objection that council may have. But right now, it's merely the investigation as he's testified as an arson investigator.
Thank you, Your Honor.
Thank
You
you.
may continue to testify.
You may continue to testify.
So based on your training expertise.
so it had the hallmarks of possibly incendiary type fire, which is arson, because irregular fire marks can indicate that an accelerant was used. You wouldn't likely see individual burn patterns that were irregular throughout a house. If you're going to see that, they'd be clustered together, and there might be some other explanation. Now, that in itself is not always the case, but it's a good indication. That, coupled with the domestic situation, led us to believe that there was possibly a crime. And based on that, I thought it prudent that we get a search warrant to go in and conduct our origin investigation.
Were you able to obtain a search warrant?
That's correct.
And then you go on and continue to conduct the investigation?
That's correct.
What happened? How did that begin? Did you have to apartment complex?
So generally speaking, when I investigate a fire, I go from outside in, least amount of damage to most amount of damage. It was very clear from the outside of the apartment complex that the fire had originated from apartment 112. I went inside. There's heavy soot in the hallway stairway area. Smoke that banked down, but no fire there. We proceeded into 112.
What did you notice in room 112?
In apartment 112, there's a living room, so there is no signs of what I would consider to be char or things that were on fire, just heavy smoke damage and soot.
What is char?
Char would be something that was caught on fire that actually had been consumed or burned.
So from the living room, did you observe anything else in there?
No, we proceeded throughout the apartment.
Where did you go next?
We went to the hallway, which is heading towards the west side of the apartment. The hallway runs north to south. It separates the master bedroom from a secondary bedroom and a bathroom and closet in between.
What did you notice in that area?
We noticed in what I would call the non-master bedroom, located on the southwest corner of that apartment, there was some smoke damage, heavy soot, but nothing to indicate that the fire originated from there.
Where did you go from there?
I proceeded to the bathroom from there, where I also located heavy soot and what I consider thermal damage from heat, but no indication that the fire originated from there.
From there, where did you go?
Into what I would consider the master bedroom, located in the northwest corner of the apartment of 112 on the second floor.
In the master bedroom, what did you do? What did you observe?
Heavy fire damage. The bedroom door was totally consumed. There were holes in the floor, including one that firemen had stepped through. And in the northeast corner of that bedroom, we found what we consider to be the origin cause.
Why did you consider that to be the origin of cause?
At this point, we're getting into more detailed things that are within the fire report.
And I'll object on lack of foundation. Thank you.
All right, I'll sustain the objection.
All right. Did you notice any candles in the apartment?
There were candles in the living room.
Is there anything suggested that recently to you?
No,
Did you notice any cigarette butts inside the apartment?
no, I did not.
you notice anything that would indicate any sort of an electric fire if you have the ability?
That is also in the origin and cause report.
Yeah, object, inspector. Thank you.
Okay, sustained.
No further, actually, Your Honor, may I approach?
You may,
I see what's been marked as People's Exhibit 1.
you may.
May the record reflect, I am handing what's been marked as People's Exhibit 1, Plaintiff's Exhibit 1 to the witness here.
The record may so reflect.
And this is the exhibit we discussed previously.
Right, this
Your
is
Honor.
the plaintiff's exhibit 1.
Thank you. No, that was included in our discovery package. So thank you, Your Honor.
Do you recognize the document you're holding?
Yes, this is the origin cause report authored by now acting fire marshal. I'm sorry, Fire Marshal Mark Berger. He was only acting at the time, but now he is the fire marshal. This is the first report he has prepared for that incident on June 19th, 2021.
Thank you. No further questions, Your Honor.
Any cross-examination?
Sure. Just briefly, Detective, to the best of your knowledge, how many people lived in that unit?
I was told one.
Okay. But how many people lived in the building at the time?
Without having to do a head count with the different paperwork we have, I couldn't tell you.
Okay. But you said there were 4 separate units per building, correct?
No, I believe I said there are 3 separate buildings. They're all connected, and there are 4 apartments in each one of those sections of the building. So if you're looking at it from the north side facing south towards the front of 3605, it would look like there are 3 sections all together with 3 main entrances, and each main entrance would go into each subsection of the apartment building, and each one had, I believe, 4 apartments.
Okay. So
Maybe less.
in total, how many apartments were in this structure? With the 3 buildings combined, as you described.
Okay, this is something that was beyond the purview of my investigation because it was handled in ordinate cause. It's not something that I would know off the top of my head because I didn't need to.
Sure. But when you went to the initial building where this apartment was located, you can testify that there were 4 other apartments in that building, correct?
Correct.
Okay.
Yes.
And when you arrived at the scene, were there other occupants milling about or in the general area?
When I arrived, it's my understanding that previous to my arrival, there were many people there. When I arrived, not so much. There are just a handful of people that were kind of still gawking and looking at the fire.
Okay. And approximately what time did you arrive at the location?
I believe 6:06 a.m.
6:06 a.m.
Yeah, in the morning.
in the morning. Okay. And to the best of your recollection, approximately how long did you respond after the initial calls started to filter in? Describing the alleged incident. Did you later on?
No, I was brought on later on.
Okay. So you were not an initial responder to
No,
this
I
case.
was not.
So describe then, to the best of your recollections, when were you requested then to go to this location? Do you recall approximately what time?
Well, the first time was around 3 o'clock in the morning. I told them I wasn't coming out then because it didn't meet the requirements of my call
Okay. But then around 6 o'clock, you went out later.
out. That is correct.
Okay. And by that point, there were still people out in the area,
There
correct?
were very few people out at that time.
But to the best of your knowledge, there were a lot of people in the area when officers first responded, correct?
To the best of my knowledge.
Okay. And so you were in the apartment approximately 6 o'clock in the morning then?
No, I was not in the apartment. We
Okay.
didn't enter the apartment until approximately 12:30 after we received a signed search warrant.
Okay. So you didn't enter the apartment until approximately 12:30 the following afternoon, correct?
No, it's the same afternoon.
Same
The
afternoon,
same day.
same day?
Yes.
Okay. And in terms of the apartment itself, do you recall seeing any possible ignition sources? Did you see any lighters? Do you see any matches? Did you see any sort of materials like that?
Do believe there was a lighter in a curio cabinet.
Okay, so you observed a lighter in the apartment itself?
I do believe so.
Okay. And did you observe any smoking devices in the apartment? Maybe pipes of any different type of nature, cigarette butts, cigars, any sort of smoking device for personal use?
No, I did not.
Okay. Did you observe any pipe material that could be used in the apartment for a smoking purpose? Sure, small cylindrical pipes that might be used, for example, to smoke crack.
I did not see anything like that.
Okay. How about ashtrays?
Ashtrays?
Yeah. Did you observe any ashtrays in the apartment?
Not in the origin of cause, no.
Not in the origin of cause, you said, but in the apartment itself?
I don't recall.
You don't recall? Okay. And in the apartment itself, do you recall observing any, say, trash bins or anything like that that might have had ashes, cigarette ashes, possibly something like that?
There was a trash can.
Okay, there was a trash can. Did you inspect that trash can all?
I did.
All right, and what did you find in that
It
trash
was
can?
unremarkable.
Okay. Did you find any evidence inside the apartment that somebody had been smoking?
No, I didn't see any cigarettes. I did not see any ashtrays.
Okay.
At this point in time, I should just tell you that I'm looking for criminality of a crime. I'm not looking for the necessary cause of the fire. That is not the purview of my job.
Sure, you're not an arson investigator. You're
No, I am
a police
an arson
detective.
investigator.
Yeah, but you're a police detective, correct?
That's the main function, is to investigate the criminal aspect of any type of fire that I am asked to respond to.
Sure, but the cause of origin was determined by someone else, correct?
That is correct.
All right, and that was Captain Berger, now Chief Berger, correct?
Fire marshal.
Fire Marshal Berger, excuse me.
Correct.
Okay. And where do you recall finding that waste bin?
I was located, I would say, just up in between the kitchen and where the dining room table area is.
Okay. And did you go to the patio at all?
Yes, I did.
Was the patio door open?
I don't, it was partially open, yes, I do believe so.
Okay,
I don't know if it was open or shut, prior to my arrival.
okay. And to clarify, by the time that you had arrived at the scene, officers had been at that location for how long? Best of your knowledge.
Well, police responded, saw the fire at 1:19 that morning on the 19th. And then the fire department was quick on their heels. So they were there potentially the entire time until I arrived at 6:06.
Okay. So by the time that you had arrived to the location, officers had been there, the fire department had been there, correct?
Excuse me. That's correct.
Okay. And in terms of the bedroom itself, what did you observe?
I observed, it appeared to me that the bedroom had gone to, I'm going to answer these questions. I would really like to be an expert witness. I don't know if that's it.
No, you can testify to what you observed as an officer who was in a location.
Yeah, I understand. Yeah, I will do that.
And that's what I'm asking you,
Okay.
not your expert opinion on anything. I'm just asking what you observed. when
I
you walked
understand
into
what you're
the-
saying now, sir.
Thank you.
Okay. Yes, when I went to go to the north, the master bedroom, that I saw the door had been consumed. I saw there were holes in the floor. I saw that the room had gone up to flashover, which means full room involvement. The whole bedroom had been on fire. I noticed there were fire effects and fire patterns and.
I'm not asking about,
Well, you did specifically say, sir, so
I'm just asking what you observed,
I'm telling you what I observed.
but. Okay, so In terms of the living room itself, what did you observe?
What in particular?
Okay, did you see, for example, overturned furniture? Did you see anything askew?
Yes, there was an overturned couch, I believe.
Okay, did you observe clothing on the floor of the bed?
Yes.
Okay. Clothing strewn about all over the place,
Now there's clothing on fire.
but it had been extinguished by that point, correct?
Yes.
It wasn't actively on fire.
No,
Okay. So you saw charred clothing.
that is correct.
Okay. And in terms of the kitchen, what did you observe in terms of the kitchen?
Heavy soot and smoke indicating that there was a lot of smoke in that area. And then it banked down low enough to leave a specific line across the wall to show where it had been. So the line of demarcation.
What about a lamp? Did you observe a lamp in the living room at all?
I don't recall.
Okay. Did you observe any Buddha statues or other items in the living room?
No, I observed those on the ground outside the apartment.
Okay. So when you initially responded then, did you go immediately up to the apartment or did you observe kind of the grounds around it?
I observed the ground because I put up police tape.
Okay. Nothing further, Your Honor. Thank you.
Redirect.
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Any objection to this witness being excused, Mr. Sartz?
No, Your Honor. Thank you.
Okay, without objection, witness is excused, may
Thank you.
stand. Any further proofs, Mr. Wisty?
No, Your Honor.
Do the people rest? Mr. Sartz, any proofs today?
No proofs, Your Honor. Thank
All
you.
right, thank you. Mr. Wisty, would you like to proceed with motion for bind over?
Yes, Your Honor. So I would move to bind over on count one. That is the arson charge. What needs to be shown is that this was a multi-unit building located in Ingham County. As an element, I think that was shown several times. This was an apartment complex. Then we can determine that there was a arson from both some of Mr. Wanacott's testimony as well as the arson investigation report that's been entered into evidence, which determines that the cause. Believed to be an open flame incendiary device that was used to ignite combustible materials on or near the floor of the master bedrooms. As the opinion of the arson investigator, the fire was incendiary. So what we have is a report saying somebody started a fire in this building, that the building was multi-unit. And then from there, we have testimony from Mr. Wright that he's in a relationship with Ms. Horton, the defendant here. He identified her. She came over on that evening. There was a dispute between the two of them. Nobody else was in the apartment complex. He left as he's looking back. He doesn't see anybody coming in or out. And then the apartment is found to be on fire, either 10 to 15 minutes, as he recalled testifying to police officers rightly today. He said he could not recall if it was 20 to 30 minutes. People would argue the 10 to 15 is more credible as it came earlier in time and this did occur a long time ago. That was done a couple of days after this occurred. So what we have is a building, a fire, and we have circumstantial evidence and motive that the defendant is the only person who would have the opportunity to start the fire, and also as the motive has a reason to, due to the dispute going on with Mr. Wright, Your Honor. And the people would also move to bind over on two additional counts. Would you prefer we move to do that now or after the first?
I'll hear on the two additional counts.
We also move to bind over on an added count 2 of home invasion first degree. Here we would argue that although the testimony was somewhat confused, I think Mr. Wright clarified that he did not give as the defendant here any permission to enter his apartment. She arrived on the front door. He opened the door to see who was there. She pushed past him and past the door. That would be an entering without permission in the dwelling, same location as what was eventually involved in the arson. And then while in the dwelling, there was a commission of both probable cause to show commission of an arson as well as probable cause to show commission of a felonious assault, which the people will all be addressing in shortly. And lastly, there's also evidence either that she was armed with a dangerous weapon, being the knife involved in the felonious assault, as well as evidence that Mr. Wright was there. Mr. Wright was there, and he's a lawful person to be present in the residence. And I believe that evidence meets the elements for first-degree home invasion, Your Honor. And lastly, we would be adding a count 3 for felonious assault. Elements of that are assault on a person when armed with a dangerous weapon. We heard testimony from Mr. Wright that the defendant held a knife towards him in a way that made him feel threatened. Testimony that she was close enough that she quickly could have acted with it, and he felt as though he was in danger of being stabbed. I believe those are the elements of felonious assault, Your Honor.
Response?
Thank you, Your Honor. The defense would object to bind over here on several grounds. First of all, the detective noted that the venue here was actually Eaton County, and the prosecutor has not presented evidence that it was within Ingham County or within 1 mile of Eaton County. So at this point, I would object on venue grounds because there was insufficient evidence to support that this is actually located in Ingham County within the jurisdictional grounds of this court. So I would object to the bind over first on venue grounds. Second, as relates to the testimony that was provided here, the people have not met their burden to request bind over on either the original count, the first count, arson first degree, or counts 2 and 3. There is no evidence that has been presented that sufficiently connects Miss Horton with being in the location or as the person who allegedly started this fire. The only testimony, even if it was taken at a light most favorable to the prosecutor, was that their drunk complaining witness who testified that they were in a relationship and who came up with this unbelievable story that somehow this person got past this downstairs door, which was somehow left open, and then somehow managed to barge past him, even though he was looking at a keyhole. That story makes no sense. And the witness himself admitted that he was drunk at the time. He didn't want to cooperate with the police because he had warrants. So that certainly leads some questions about his credibility as it relates to his impeachment, which the prosecutor impeached him on later regarding the time difference. The bottom line is he didn't see anyone egress or either enter or leave the apartment after he left. And there is a significant time gap and testimony that there's no one else in the apartment or no one else in the building. Obviously, that's not credible either, because the detective testified, there were multiple apartments in that building at the time. That the detective noted that, to the best of his knowledge, there were a lot of people who were milling about the location. You're talking an apartment building with, at least based on the detective's description, at least 12 apartments. And he didn't want to speculate or testify to that, but he laid out the building plan and noted all the different apartments that were in each of these buildings. So quite frankly, at 1 o'clock in the morning, Judge, it is beyond the scope of credibility, even for the low standards of a preliminary examination, that no one would have been around the building at this time. That story just makes no sense. And you have all these biases against Miss Horton, which are obvious and very apparent based on the complaining witness's testimony, who was the only witness that the people have produced here who can attempt to at least testify at some time close to the alleged incident. But even there, he took off. He made up this story about an alleged knife, some fight. He doesn't deny the two had a pretty heated altercation, though. That part was pretty clear. This drunk older man who is making up this story now about this knife is now claiming that miraculously he had no idea that anything was going on with this house or anything else after he left. He claims that he later on heard a phone call from somebody that his house was on fire. So that entire time that he left, he didn't observe any fire. He didn't observe anything else. He went over to Dollar General. Why? I don't know, because it was 1 o'clock in the morning. So he couldn't see. And that it would also be an added reason why there's no credibility here behind his story. The burden of proof in a preliminary examination, Your Honor, is very low, but the people have not even met their burden here for the purposes for bind over on count 1 as it relates to the home invasion charge. Obviously, there are significant questions about his credibility regarding whether Miss Horton had permission to be in the apartment at the time. He made it very clear that Miss Horton was his girlfriend at the time. He made it very clear that she was able to enter the apartment, go through the door. So his statement later that, well, she didn't have permission to be there or whatever else, that is highly suspect, not credible at all. And further, in terms of the description of this alleged knife, we don't see any exhibits here of any alleged knife that was used. This gentleman never described what this object looked like, what it was shaped like. All he claimed was some very broad, the only term he used was that it was a knife. Well, we don't even know if legally it would have met the definition of a knife. Was it more than 2 inches long? What type of alleged knife was this? No evidence of it. Just this drunk person who admits that he was in some type of altercation with his ex, claiming that there was some type of knife. That's it. So, Your Honor, respectfully, based on the evidence presented at this preliminary examination, the people have not met their burden. And further, based on the evidence presented, it's arguable whether venue is even appropriate here. Thank you, Your Honor.
Response?
Thank you, Your Honor. To address the venue first, I believe Mr. Wright did testify it was in Ingham County. I also believe that the court can take, we've had testimony of the address and location of this apartment complex. It's in the city of Lansing. From that, I believe the court can take judicial notice that that location is within its county. From the address and city of Lansing that has been provided, at least on a probable cause standard, regarding a lot of what the defense counsel had raised are issues of credibility. Issues of credibility should be determined by the trier of fact at trial, not here for a preliminary examination. We did hear testimony to support the elements here. Regarding the knife, we heard testimony that he was afraid of the knife. He thought he could be stabbed with the knife. I believe that works to the level that it is a dangerous weapon, regardless if it meets a legal definition for possession of a knife. If it's a dangerous weapon, if it's something he feels can put him in harm and be stabbed with, I believe it meets that definition. And we do have here, that's been presented, strong evidence that the defendant was the one with the opportunity there and a motive, and I believe that does meet the probable cause standard here, Your Honor.
Well, the court has reviewed. There's the testimony of Mr. Wright, the testimony of Detective Jeremy Wanacott, and the plaintiff's exhibit 1, which is the Lansing Fire Department's fire marshal structure fire report, and that was prepared by Captain Berger on July 7th, 2021. The date does not seem to be at issue, June 19th, 2021. The location of 3606 Bayview or 3605 Bayview, apartment 112, City of Lansing, Ingham County, was testified to by Mr. Wright. We'll talk about Mr. Wright's testimony later, but that does, the venue as in Ingham County, Michigan, appears to be at a probable cause level to be set pursuant to location and venue on City of Lansing, Ingham County, State of Michigan. Identification was made by the defendant to the defendant by Mr. Wright, Terrence Wright. So location, venue, ID, and date do not seem to be at issue here. There are some concerns with Mr. Wright's testimony, and that is to go to the credibility of the trier of fact. Mr. Wright indicated on the stand there had been drinking involved. There may have been some drug use involved. Credibility, there are credibility issues. Of course, the standard here is probable cause at the preliminary examination stand at the stage. Probable cause to believe that the crime was committed, and probable cause to believe the identity of the person who committed that crime. The identification's been met. The probable cause, there's certainly credibility issues that will be addressed in a different court, probable cause being the second lowest standard, beyond reasonable doubt being the highest standard. And quite frankly, opposing counsel's right. Mr. Wright does have some credibility issues. There's no doubt about that. However, the court finds that in regards to count one, which is that the crime of arson in the first degree is met at the probable cause level. The defendant burned, damaged, or destroyed by fire. The identification of the individual who did this is circumstantial. However, there seems to be, at least at the probable cause level, that the defendant was the last person in the apartment. The apartment is a multi-unit dwelling pursuant to the first degree arson, and that the defendant had been left alone there after what Mr. Wright described as a tussle, indicating some domestic situation, and that he had been in fear of being stabbed, and therefore saw his things being thrown at 1 o'clock in the morning. He leaves the residence. I'll let the trier fact to figure out why he leaves the residence at that time, but he leaves the residence for his own safety. And 15 to 20 minutes later, depending on what version, there appears to be that he made a statement 10 to 15 minutes later. There also seems to be, today he testified to 20 minutes later, he turns around and he sees that his apartment is on fire. The person who is not permitted entry is the only person left, who is the defendant, in the apartment at the 1 o'clock in the morning time. So the circumstantial identification is made as to the offense element, that the apartment is burned. That is all necessary to count as burning. The property does not have to be completely destroyed. The property is not burned if it is merely blackened by smoke. We seem to have the exhibit 1 and the testimony that there was much more than smoke, that they actually was an incendiary device ignited the apartment complex, and that it had not only damage from fire, but that it also been charged. For our purposes, burn means setting fire, doing any act that results in the starting of fire, aid, counseling, inducing, persuading, or procuring in another do such act. And damage, in addition to ordinary meaning, includes but is limited to charring, melting, scorching, burning, or breaking. All of that is indicated in the fire marshal report, plaintiff's exhibit 1, that indicates that an incendiary device set fire to the apartment in a multi-unit dwelling. They indicated that each complex holds 4 separately addressed townhomes and are connected by a common attic and basement. So it would meet the definition for the probable cause level of a multi-unit dwelling, which addresses our third element, which is the property that was burned, damaged, or destroyed was a multi-unit building or structure in which one or more units of the buildings were dwellings. It does not matter whether any of the units were occupied, unoccupied, or vacant at the time of the fire explosion. We have testimony that this is where Mr. Wright lived. There's some testimony that, and in the fire marshal's department, that the Red Cross was called out for additional, at least called out in regards to the additional tenants in the building. So we have the building, it meets the definition, and the dwelling meets the definition. Third, that when the defendant burned, damaged, or destroyed the property and its contents, intended to the defendant to burn, damage, or destroy the contents, or its intentionally committed act that created a very high risk of burning the property or its contents while committing the act, the defendant knew of the risk and disregarded it. It appears that the defendant who was last in the apartment building, from the report, indicates that it started from the main bedroom, and then the report goes on to list why an incendiary device was used, or an incendiary flame device was used in that main bedroom. And oxidizing agent was oxygen, so it was started without any type of accelerant. However, it does discount in the report any electricity damage, any cigarettes damage, any candles or incense damage, any weather damage as a result of the investigation by the arson investigator. So I believe that at a probable cause level, Mr. Wright's testimony, along with Mr. Wanacott and the People's Exhibit 1, that first degree arson is met, that the defendant did willfully or maliciously burn, damage, or destroy by fire, explosive a multi-unit building or its content in which at least one of the units was dwelling, contrary to 750.72. So that is bound, the court binds over on count 1. Count 2 is the added home invasion count. There was seemed to be Mr. Wright, and once again, I'm cognizant of some of the credibility issues that Mr. Wright brings, but the defendant broke into the dwelling or was actually told not to come in, did enter the building, and indicated that Mr. Wright indicated that the defendant was not allowed to be on the premises to the best of their knowledge, were not allowed at any entry. So entry was made, and at some time during the tussle, while Mr. Wright was present, the defendant did brandish a knife and scared Mr. Wright, according to his testimony, in regards to being stabbed, which is one of the reasons why he left. So entered a dwelling without permission, entered the dwelling, and then while was in the dwelling, did come into the dwelling, and then did commit a felonious assault, or did brandish a knife at Mr. Wright, and then committed the act of arson before. That's the allegation at a probable cause level. Committed the act of arson before they left. So when the defendant was present or was leaving the dwelling, committed the offense of both felonious assault and first-degree arson. The defendant entered, was present, or was leaving the dwelling. Either of the following circumstances exist. So you have the initial unlawful entry, and then you have the crime was committed, either arson or felonious assault, and then the aggregating factor that they were armed with a dangerous weapon is met because of the knife, and then the person living in the dwelling is also met because Mr. Wright is a resident of the dwelling. Therefore, both aggravating factors are met for home invasion first. Home invasion first is a 20-year felony, and that's pursuant to 750.110A. So that's the added count 2. The added count 3, which is felonious assault, it would be the charge that is incorporated in home invasion 1. But I do believe that there's probable cause at the probable cause level to believe that the defendant committed felonious assault on that date at that time, 3605 Bayview, apartment 112, city of Lansing, Ingham County. The defendant is identified as being a person who put the victim Terrence Wright in fear by brandishing and then placing a knife towards Mr. Wright, who acted in fear and then continued on. There is some question as to the nature of the knife. There is some question as to where the knife is at this point. However, Mr. Wright's testimony for the probable cause standard meets the felonious assault measures. I believe felonious assault is 750.812. With that understanding, the defendant is bound over to circuit court on count 1, arson in the first degree, count 2, home invasion in the first degree, and count 3, felonious assault. So bound over for trial in circuit court at a different standard, which is beyond a reasonable doubt. Anything else, Mr. Wisty, on docket 2201517?
No, Your Honor.
Anything, Mr. Sarks?
Thank you, Your Honor. Just briefly, I would request the court consider a bond modification, and there are some very important medical reasons as to why. Ms. Horton is currently on tether, Your Honor. She has been out on tether now for an extended period of time. She has been faithfully complying with all the bond conditions, been reporting to pretrial services. But, to get into some of these specifics right now, this tether is causing her significant hardships. For one thing, it is causing her physical injuries. The tether, the rubbing against her ankle has been the source of injury. The second complication is because Ms. Horton is currently raising 2 very young grandchildren and helping her daughter raise her grandchildren. And they're 2 and 3 years old. And the 2-year-old and the 3-year-old, that can lead to some complications in terms of that device because of their age. Ms. Horton is in very close contact with both of them. being 2 and 3, they like to play around with things, they like to touch things, they like to explore things. Well, that's been a source of some complications where they've decided that they want to go ahead and try to play with the tether device, which certainly is, the reality of raising 2 very small children is that you run into these types of situations. And for lack of a better term, Your Honor, it's very hard to childproof a tether device, especially when the grandchildren are playing around with Miss Horton. And it's also quite a complicated matter when they start asking questions about what this device means. And they've had very tough circumstances in their lives, the 2 and 3-year-olds. And this leads to a very difficult conversation that Ms. Horton has to have, for example, with medical professionals who are treating the 2 and 3-year-old. Ms. Horton has deep-rooted community connections to the community. She's not a flight risk at all. Your Honor is well aware that this process could take many, many months before we see a trial on this. And I do anticipate we will be seeing a trial on this case. And, she has been complying faithfully with pretrial services. She will continue to do so. Obviously, there's no allegations of any contact. Respectfully, the safety of the community can be met here if you pull her past criminal history as well. Certainly, there are people with worse backgrounds walking around with PR bonds without tether. She has a stable place to stay, 413 Hartford Road, apartment 32, and over off of Waverly Road. So she's away from the address, away from the location. So it's an unusual request, but the biggest issue here, Your Honor, are specifically her grandchildren. This tether right now, combined with the risk of some potential physical injuries, is causing a tremendous amount of challenges for Ms. Horton. Thank you.
A response, Mr. Whitstein?
The people would oppose such a motion, just given the serious nature of this charge, Your Honor. It is accurate. She has complied with the conditions up to this point.
Mr. Whitstein, what is the prior criminal history here?
We've got, it's quite extensive. There's some prior felonious assaults. Last thing on the record is a 2020, but that is an OWI 2016. There was a dismissed felonious assault. 13 and 2013, a felonious assault, ordinance violation.
Right.
So it's drunk driving and assaulting charges.
Based on the criminal history, I did not have an entire copy of the criminal history. And the nature of the offense is a life offense, not to mention the count 2 is a 20-year and count 3 is a 4-year. I do have a prior failed to appear in June 23rd of 2022 that was signed by Judge Alderson, it appears, or magistrate. DFT arraigned bench warrant on June 23rd, 2022. But given the circumstances, Mr. Sarge, did you want to be heard on that?
No,
All right.
but sorry, we're not familiar with.
All right. I just have it written that there's.
She was summoned to appear in attorney.
All right. So she was summoned on the complaint and then failed to appear at the original arraignment and then was arraigned.
Probably because she had to turn herself into the jail
Right.
and try to appear by Zoom. I
Right.
think that was the issue. But then she did turn herself in.
She did.
And she got arraigned. So yeah.
Based on the prior criminal history and the nature of the offense, and I'm gonna deny the bond reduction motion. A bond is set at 20,000 cash surety. And I understand the bond reduction was really as to the tether. I'll leave tether in place for now. I think that could be readdressed in circuit court based on some of the circumstances. But I'll reduce I will deny the bond reduction at this point. Mr. Whiskey, would you like your exhibit back, plaintiff's exhibit 1?
Yes, Your Honor.
All right. With that understanding, anything else on docket 22-01517, Mr. Whiskey?
Nothing from the. people,
Anything
Your
else,
Honor.
Mr. Sards?
Nothing further. Right?
All right, thank you. Your next date, ma'am, will be in circuit court. Please keep in contact with your attorney, Mr. Sards.
Yeah, you should.